Hey everyone, it's Rob Ryder again. It's still May 18th, 2013 on a Saturday. My email address, quarterrecord, AOL.com, TalkShow ID. The call ID is 122402, taking clues from ancient books. If you can, please do donate. You can do it by PayPal, ASHLEYRYTLEWSKI@gmail.com. That is the account. Or snail mail works too. Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. Soon enough, all that'll go away. And many people have asked me, since we're talking about DBAs and what it could mean and what it will mean and everything else, your business name is your all capital letter name, as it is on your birth document. Any other variation that's out there isn't something that you contrived, they did, right? But this original one is yours. And so by reference, it will reference every other one in the paperwork somehow. The Vatican knows where all the money is. Don't worry about it, right? They can track everything. But it goes back to the root. The root is what's on your birth documents, and that is Robert Allen Rytlewski. On my document, it calls Robert Allen Rytlewski a child. And it says, now remaining in my office, talking about the county clerk. That's where the child is. Want to claim the child. What they did, though, they gave us by operational law what they call a true real name, which is Rytlewski, Robert Allen, the surname coupled with the given name. And the funny thing about surnames is surnames are only used with proper name. That's what a surname is with. Okay, we talked about this before. I want to go through it real quick. There's things called ex parte, right? I mentioned in the video I did earlier that the clerk said, oh, you can't see the judge, that's ex parte. Well, what the hell does ex parte mean? Ex parte means basically the same thing as a petition or an application. And that is something that's done in the Court of Chancery. And so it's like the application of Williams or the petition of Williams, ex parte Williams. And in Chancery, you don't put it into a court case, you give it to the Chancellor. Chancellor is the highest ranking, basically like the Secretary of State of the district or whatever it is you're in. It could be a district, could be a province, could be a state. Who knows what it is? For whatever size jurisdiction that is, the Chancellor acts as the Secretary of State. But more importantly, it's who you send your petitions to, because it's a bill of complaint. It's a version of a bill of complaint, and those are done in courts of chancery. In some jurisdictions, ex parte has been replaced with in re, which means in the matter of. And if you go look at court cases and stuff, you'll see things that are in the matter of. However, most jurisdictions reserve the term in re for proceedings concerning property. So in re Williams would be in the matter of Williams' property, not in the matter of Williams, but his property. In re, Latin, in the matter of, concerning or regarding, the usual style of the name of a judicial proceeding having some item of property at the center of the dispute, rather than an adverse party. And I can tell you where you can find something like this. Where is that thing? Right here. This is a notice of motion. And what does it say right here? In re, and it has to do with a marriage, custody. So regarding the property of the marriage, the custody, the support of, the order of protection, the parentage, other. Regarding the property, in re. So it's used like in all things in family courts right now. Regarding the property. Where was that? So, right, regarding the property of a company, right? So if they put in re and your all capital letter name, they're talking about regarding your property. Sometimes in re is used for proceedings where one party makes application to the court without necessarily charging an adversary. So there isn't even necessarily a dispute. Right? So if you're not charging an adversary, you don't even notice them. You just go directly to the judge. Because one of the other things in re is a hearing without notice. You're not noticing the other party of the hearing. And this goes back to what Patrick found out, that you can see the judge. You just need to write him and tell him you want to see him. So you want to go there in regarding your property of the Klein Company, and you're the owner by your true name. All right. So regarding the business property, the true name by operation of law is me. I claim ownership of it, and I would like you to get the records for me. If they just won't give them to you. Okay, such actions instead of English translations in the matter of such actions may instead use the English translation in the matter of, or the Latin words ex parte. Ex parte and the matter of, in re, all mean the same thing. The final decision, the style, is made by the clerk of that court for a particular lawsuit. So possibly there's more than one kind of lawsuit, and so you would use a different form. It could be in re, ex parte, in the matter of. And then there's in rem, a lawsuit against an item of property, not against a person. So who's the defendant in a foreclosure? All caps. It's not against a person. If it was against your person, your natural person, would be upper lowercase. If it was against you, the living man, it would be Ratluski, Robert Allen. An action in rem is a proceeding that takes no notice of the owner. In rem doesn't care who the owner is, but determines rights in the property that are conclusive against all the world. In other words, it's going to go look at what's in the court of record to see who's down as the owner with the rights to the property. Well, right now we're the unknown owner because we haven't done our DBA to say, that's my property, I'm the owner. The object of the lawsuit determines the disposition of the property regardless of who the owner is, right? It's going to dispose of the property, doesn't matter who the owner is. Interested parties might appear to make out a case one way or the other. But the action is in rem, which means against the things. Those that are interested show up. Last man standing gets the property. In rem lawsuits can be brought against property of debtors and for the enforcement of liens. They may be directed against real or personal property, which is really what they're after, right? They want those pieces of paper. In rem actions are permitted only when the court has control of the property. And way back when now, a few months, time flies, Bob in Pennsylvania had a judge put on the order that it was he had given an in rem judgment, which means that he was saying he had jurisdiction over the property. But when they give an in rem judgment, it means he has jurisdiction over the property, and basically he's fining for the plaintiff, although he doesn't really believe the plaintiff is the owner. That was back in the other video, right? Just you have to go find it and watch it. The in rem jurisdiction of court may be exercised only after parties who are known to have an interest in the property are notified of proceedings and have been given a chance to present their claims to the court. Well, here's the thing. The owner has never been notified. When they send you a summons to court, it's in the name of the business. It's not in your name. Therefore, the owner has never been notified that there's a court case against his property. And they're trying to do an in rem action, and they can't do it because they haven't given you proper notice. So you just tell a judge, I never got proper notice. Here's my certificate of ownership. I never got proper notice about this case. And we'll see where this plays into the annotated laws of Michigan. So, okay. Now this is the book that Joe was referencing on the video earlier today for Arizona about trade names and trademarks. And Bobby in Arizona called me because he'd looked through it, and he said, just put the word court up here in the search, because it's a PDF. You can find it online, Department of State, Trade Names, Trademarks, 24-page PDF. And do a word search on words such as court, and trade name registration cancellation. A court of competent jurisdiction orders the cancellation on any grounds. Here's one of the things. The trade name for your decedent family members has never been closed down, right? The death certificates haven't been taken and put into the office of the recorder to be recorded that anybody's dead. They're just deceased, presumed dead, because they don't seem to be around. Right? They may have been taken to a hospital, had a funeral, did everything else, and the certificate is there, but the certificate has not been taken to the proper office to be recorded. So that's one of the things we're going to have to do is cancel the trade names of our ancestors. But here's a good one. So this has to do with a certificate of registration, admissibility as evidence. Upon compliance by the applicant with the requirements of this article, the Secretary of State shall cause a certificate of registration to be issued and delivered to the applicant. The certificate shall be issued under the signature of the Secretary of State and the seal of the state, and it shall show the name of the business and the name and business address, the date claim for first use of mark anywhere, and the date claim for the first use of the mark in this state. So what's the date it was first used? Your birth date, your day of birth. A class of goods and services, yada yada, reproduction, registration date, term of the registration, a certificate of registration issued by the Secretary of State under provisions of the article or copy thereof, duly or certified by the Secretary of State, shall be admissible in evidence as competent and sufficient proof of the registration of such mark. Now they're saying mark, but it's name also, name, in any action or judicial proceeding in any court of competent jurisdiction in this state. In other words, foolproof evidence any place in the state. When you get this certificate that they really don't want to give Joe so far, although they did give him one, they just wouldn't take his money. They didn't follow the rules. And so we're going to point out their error, their procedural error, and say, if you don't correct this, I'm going to have to go take it to the chief judge. Now, I don't know if the Secretary of State has a inspector general. Call them. If not the inspector general, do they have an ombudsman? Call him. But at the end of the day, take it to the chief judge of the Supreme Court. It's a matter in equity, directly to him. Do a petition in regard to your property. Show them what you're trying to do. I'm trying to follow this law. They won't allow me to do my trademark. And they can't show me the law that says I can't use my birth name. Right? They can't do it by the custom. Right? They need to do it by the law. And how do you make them do it by the law? You treat them like they are. They're just an officer in a chain of command, and I'm going to go to their boss. So, you know, the trademark, trade name are going to be very important, and we may have to do it at the federal level even. Apparently they got a really easy form for trade names also. So you may have to do it in the county. Hell, you may have to do it in the city. You may have to do it in the state. You may have to do it here. Wherever it is, right? It's just a very simple form. But eventually you're going to get to the point of you have exclusive use of the name. And by just claiming it to start with, any place, right? Now you have the presumptive evidence that it's your name. If anybody has anything else in your name, they need to bring their certificate of ownership in. Well, you're the only one that has one. So it's a good book to download. All right, and this is that thing for INRI, so it's used. Oh, this is interesting. Yeah, Rose sent this to me. That's what the banks do. They get a certificate of merger. So Harris N.A., the association previously known as Harris Bank Northbrook NA, having a principal place of business, yada yada yada, has merged with some banks, and as a result of the merger, the association has succeeded to the ownership of all the property owned by the banks in their individual capacity as trustee or otherwise, right? So Harris NA is going to take over ownership of all the property of some banks. Let's see how many banks there might be. Well, here's one page. Schedule 1. All these banks now are going to do business under another bank. Right? Oh, there's one page. Yeah. Harris has got a lot of banks. A lot of different names. But now they're going to do business under one name. Well, this is really now a new entity doing business as all those other banks. They need to have a DBA. Again, I don't believe if you look at the plaintiff's name on your foreclosure and go try to find their certificate of good standing in your state, you're not going to find it. You're not going to find that they've filed a DBA. Well, then by law, they don't have access to the courts either. They just need to point it out to the judge. Right? You need to point out the things that are true. Make them go bring in their proof. By what authority do you bring this charge? I want to see your business license. Right? Now the way of looking at your DBA is it's your business license. It establishes your domicile. Okay, this is the annotated laws for Michigan that has to do with the DBAs in the county. And on my county form, it says at the top it follows particular MCLAs, Michigan Compiled Laws, annotated. And I didn't have them, and so I had put an email out, and somebody was nice enough to send this to me. But if you have access to Nexus Lexis Academic, so I'm checking in this myself, basically this is available at colleges. If you happen to have a college student that has a password to the library, you might be able to get access to it. Nexus Lexis Academic. I tried it with the University of Michigan just as a guest, and they won't let you do it that way. If I had a student ID, I could. And I didn't see if Michigan State has this, but I have a daughter there, so I'll be talking to Becky here real soon. So here's the law, basically. It has to do with carrying on business under an assumed or fictitious name. And the law itself reads just like it does if I went online and looked up the MCL. See here, they call it MCLS. Now this got an S on it. But what's really great are the notes that they put on. And first of all, a person shall not carry, conduct, transact business without, unless person files in duplicate in the office of the clerk of the county or counties which the person owns, conducts, yada yada. So what did it say do? It said file in duplicate. What does it mean when you file something with the clerk? They put a file number on it, which means the first thing they need to do is give it back to you with a file number on it, or they haven't completed step 1. They're going to charge you a filing fee of $6, right? So you don't do anything else, get that done first. It says here, $6 for filing. Go do it. They're not going to want to do that because that isn't the way they normally do it. That's what they did to Tom and Rich. When you get done with this should cost you $16. When they got done, it cost $15. It's like, well, that doesn't make any sense. That there's nothing in this law that says they can change the amount. They can do more than $6, but they can't do less. So, they just didn't do it by the law. And again, the true and real name, which is Rytlewski, Robert Allen. That's how you got to put your name. But it's these notes that are interesting, right? Per assumed name statute thereby serves convenience and to prevent imposition and fraud. Well, we'll find out. This act is particularly directed to the class of enterprises operated under assumed, fanciful, and elusive misleading names which contain no inkling of those connected with or conducting them, and has not been rigidly applied against those disclosing in the business name adopted the true surname or names of some party or parties interested in and conducting an established legitimate business. What's all that mean? Look at all the, well, I don't know how many court cases people have been involved in, but look at all the different ways mail comes to you. Sometimes middle initial, maybe not, maybe just, sometimes just in initials. All those are fictitious names, right? They have nothing to do with you. They're trying to charge you under something that really doesn't exist. They made up a fictitious name, and that's what they're charging it against, and saying it's you. So I got to find my utility bill. How does the utility send you a bill? First name, middle initial, last name? That's the way IRS does it. Right? That's a fictitious name. That isn't me. A limited partnership is a person. There you are. Right? So one of your things is your legal person, which is your all capital letter name, which means could be a limited partnership. This act contemplates only fictitious, misleading, uncertain names so that not to require filing a person who uses his own surname as part of the name of his company. But here's the problem. The surname gets attached to the proper name. If you look at the definition of surname, if I get to it in this video, I'll show it to you. It says it goes with somebody's proper name. Well, your proper name is upper lowercase. We're talking about an uppercase name, and the uppercase name isn't your proper name, it's an uppercase name. They show you what your proper name is in the definition. Upper lowercase. That's what the surname goes to. So even though it looks like your surname in the business name, that could be a last name. All right, we got all sorts of things. You got last name, family name, surname, common name. Right? Could be it's just a common name. Doesn't have to be the surname, because by definition a surname goes with a proper name. Yeah. Filing a certificate of doing business under assumed name pursuant to this act by certain individuals describing themselves as trustees of certain foreign common law business trusts, then operating in Michigan under the name and style of trust name, such trust conferred on it when organized could not operate to transfer to them any property or property rights of the trust or effects in organization and existence as a legal entity. What that's saying to me is they can never really steal your stuff. They may be acting as a trustee, but they don't have any rights to the property. They just get the administration fee for administering it to their benefit. And somehow we have a common law business trust, which we'll get into on another video what that is exactly. But we don't really have one with them. They have ours right now, but we don't have one with them. There was a common law business trust. Whoever set this thing up in the first place put something in for you. It's your property. It was a gift to you. And we've given it to them on deposit, and we've not come and taken it out of deposit. So the owners never appeared to claim his property. And they don't want to help. They don't want you to. Okay, this is for a court case. So where a plaintiff doing business under assumed name without having filed the certificate required by the statute, and the transaction upon which he founds his action is an intrastate one, judgment non obstante vertigo of the defendant is justified. In other words, you can say it's a false verdict. Because the plaintiff, if he doesn't have a certificate to do business under, or a certificate of good standing, if he's incorporated, to do business in Michigan, he cannot bring a case, an intrastate case. And if you look at the addresses, everything's within the state, right? They're not saying that they're bringing it from out of the state. Well, let me go look. I don't believe they are. Yeah, but they're trying in a state court. So, anyways, I don't think they can do it. A person doing business under assumed name may bring an action ex delicto without filing a certificate under the assumed name. which means you can file because you've been wronged, even though you haven't filed a certificate. No person is to be deprived of his right to bring an action ex delicto by the fact that he has failed to file a certificate in compliance with this section. Right? All the case law you could ever want. Sufficiency of compliance. When plaintiffs in an action of assumption prepared and signed the certificate required by this act, and one of them signed and swore to the requisite affidavit before a notary, and the notary filled in the date of the jurat and affixed the name date her commission expired, but neglected to sign her name, plaintiff's rights to recovery are not barred by such omission. So we're going to let them do it almost half right? The notary's not going to sign, and only one of the witnesses is going to come forward as a witness. It says, where plaintiffs in an action of assumption prepared and signed the certificate required by this act, and one of them signed and swore to the requisite affidavit before a notary, so one of them, but the other one didn't, and the notary filled in the date, but didn't put her signature on it, the plaintiff's right to recovery he could still do it, even though it was an omission. It's not an error, it's a fucking omission. To me, that's a felony. Effective filing certificate. Filing assumed name certificate is required to inform the public as to ownership of business and does not create a separate legal entity or affect change in ownership of property of such business. No, it just says who the owner is. So there was a lot more in the annotated than what you get online. That's for sure. And the Attorney General may not advise County Clerk whether specific proposed name should be rejected, since decision must be that of Clerk, subject to judicial review and judgment of Attorney General in any particular case. Determination, which depends upon its own peculiar facts, may not be substituted for judgment of the Clerk. The frickin' Attorney General, State's Attorney, Prosecuting Attorney, County Attorney, any attorney cannot speak for the Clerk. It's the Clerk's decision. And it's really interesting that what they told Rowan, her husband, was that when they asked him, because they always had to run to go talk to the State's Attorney, and Rowan's husband said, "Do you guys work for or who do you work for?" And they said they work for the Deputy State's Attorney. I don't think they're lying. They're not there working for the Clerk. Right? You need to get to the Clerk. Get past the troll. Quit looking at them. Go say, "I need to talk to the Clerk." If you don't work for the Clerk of the court or the County Clerk, then I need to talk to the Clerk. I want to talk to him anyways. I don't think we should be messing with the trolls. Just go right to the Clerk. Here, I'm leaving this for the Clerk. Have him give me a call. Put in an envelope, put his name on it, have him take it to him. I've come to claim my property. When can we meet? Right, here's my certificate that says the property is mine. I want my property. Okay. Anywho, a copy of a certificate duly certified to by county clerk with whose office same as file shall be presumptive evidence in all courts of law in this state of the facts contained on the certificate. Upon payment of the $10, the payee shall be entitled to 2 certified copies of the certificate without extra charge, with additional copies of $1 each. The Circuit Court of the County, the office of the county clerk, of which the certificate is filed, shall have jurisdiction of an action brought against a non-resident person, but this provision shall not be construed as depriving any other court jurisdiction against a non-resident person. Well, we're going to be a resident when we do this because we're claiming a residence. The non-resident person is going to be the bank because they're not incorporated here. They're not doing business here. They don't have a certificate. Okay, that was that one. What else do we have here? Here. Okay, this is out of Wikipedia. A surname is the name added to a given name and is part of a personal name. A personal name is a proper name identifying the individual person, and today usually comprises a given name bestowed at birth or at a young age, plus a surname. So your surname goes with your proper name. Right? What's a proper name? Peter's a proper name. And what was I doing this for? These are all just different notes of stuff I've tried to start, and I haven't really got much done, but lots of little pieces. This is for California. Somebody in California tried to do this earlier this week at the county. I think it was Los Angeles County. Got denied. So the purpose of this section is to protect those dealing with individuals or partnerships doing business under fictitious names. So individuals, right? They consider your all capital letter name an individual. That's what the circuit court clerk in Illinois told Roe, right? When she was talking about the all caps being an estate, the circuit court clerk said, well, we refer to it as an individual. So your individual wants to do business, and your partnership is when the two individuals of you and your wife get together to form a partnership. For the women, right? When you go do it, do the first one, you're doing it in your maiden name, just like on your birth document. You're going to claim that property first. Whenever there was a union of the two estates, right, from there on, then it's a 50-50 split, but you already have your own anyways. The point is, we're not after a bunch of money, because you're not going to have a bunch of money anyways. You're going to end up with some kind of ID and a freaking card that when you swipe it and sign your name, you get what you asked for. As long as you're peaceful. That's how it works in the land of man. And then you take your God-given energy and you go do what you think you're supposed to, which really should be go spread the gospel. Spread the good news. Absolutely. If we can all live at peace, we don't need to do this. Now, not everybody's going to do this, right? So there'll be plenty of people who'll still work for a piece of paper. I'd rather get what I want for giving them my signature. That's the side I want to get on. The other side of the book. And in case of an individual, a name that does not include surname. So again, if they say, well, you can't do this because your surname is in your all caps name, you would say no, the surname is only used in conjunction with the proper name by definition. Besides, you're going to have to show me the law that says I cannot use my all capital letter name, birth name on my DBA. Or I'll file a complaint with the chief judge. All caps does not use a surname. Okay, and if you don't do this, you cannot maintain an action in any state until the fictitious name statement has been executed, filed, and published as required by this chapter. The filing of any fictitious business name statement by the person required to file such statement pursuant to 17.910 shall establish a rebuttable presumption that the registrant has exclusive right to use the trade name, the fictitious business name, as well as any confusingly similar trade name. And that's what we have. There's many confusingly similar trade names we've been given in the county in which the statement is filed. If the registrant is the first to file such a statement containing the fictitious business name in that county and is actually engaged in trade or business utilizing such fictitious name or confusingly similar business name in that county. Whew. Wow, what's that mean? When you claim your birth name, all the other ones come with it. And it's rebuttable presumption now, right? That is your property. And what's the rebuttable presumption? Somebody else is going to have to walk in with a certificate like yours and say, no, I'm the owner. I don't think they can do it. Rebuttable presumption created by this action shall be one affecting the burden of producing evidence. Okay, I'm going to produce the evidence. I have the certificate that it's mine. There's my evidence. It's foolproof evidence. It can be used in any court of law. It's a beautiful day. So I told the sister, well, here's an idea for a complaint, and this isn't complete because I was just putting things down and said, let's start here. So I might write it like this: Chief Judge, my given name is Robert Allen, and by operation of law, it appears my true full name is Rytlewski, Robert Allen, and I am the rightful proprietor of, all caps, Robert Allen Rytlewski. As it is my belief that I am currently considered an unknown owner, as I have not yet registered a fictitious business name statement with the county clerk of whatever county it is for the fictitious business Robert Allen Rytlewski as its owner and sole proprietor, in accordance with the section. In the case of an individual, a name that does not include a surname of an individual, or a name that suggests existence of additional owners as described in subsection C. As a surname is linked to the proper name, as in Robert Allen Rytlewski, then the individual, Robert Allen Rytlewski, is not using the surname, and therefore it required proper registration of ownership. That's it in a nutshell. Unknown owner status would indicate the post office does not have the mailing address of the sole proprietor. And as the post office gets addresses from the county, the need of being registered for the post office to be notified of sole proprietor mailing address. Okay, anyways, you get an unknown owner's status. The post office doesn't have your address. If mail comes for Rytlewski Robert Allen, they don't have an address to give it to because they never got it from the county. They didn't get it from the county because you didn't register your DBA as the owner. Much more critical is my being denied access to state courts to maintain an action or suit regarding the contractual issues such as unexecuted bilateral contracts, being portrayed by others as unilateral contracts, and presumed gifts from the grantor to the grantee, which is what they're doing now. They're saying that piece of paper that you signed is a gift to us. And I'm saying, no, I'm not the defendant. That's my business. We have a contract, and this is business. And if we both didn't sign the contract, it's not a contract. And they're trying to make this unexecuted bilateral contract seem like it's a gift from me, the man, on a unilateral contract. By what authority does said office staff deny my lawful filing of instruments? The situation could be resolved by the county clerk's acceptance of my completed fictitious business name statement, but my attempt was denied by said office, and I have come to make your conscience aware that the denial is contrary to natural justice and equity. By what authority does said office staff deny my lawful filing of instruments required to be filed if I am to comply with the law? It could be construed as a willfully false judgment of an officer not making a judicial determination beyond the powers of their office. I don't think I had that right. Willful false judgment officer not making judicial determination. As I said, it's a work in progress, making a judicial determination beyond the powers of their office. This assumes that office has filed for record the required oath and bond of elected and appointed officers. In other words, the person that's doing this, that's telling me I can't, do they have the authority to say anything? Have they filed for record their oath and bond as required by the Constitution? Or maybe they made a correctable error, but until such error is corrected, it stands as an omission and dereliction of duty, or the acts of a usurper. If in the name of justice, I ask that you see to the proper registration of my completed fictitious business name statement that I have included with this sworn complaint. And then you'd have to put a closing thing, and that you swear that everything you said is true. Right? So you can find that stuff in other documents. But the idea is to point out that you've gone down to try to do this. Here's the law you're trying to follow. I guess I would have put that in there, that right, per this particular law, trying to do this or not, let me do it. Just an idea. I'll let somebody else think it through. Or I'll think more about it later. But if you had to do something Monday, there's something you could do. And what else we got? So you want to put this stuff in a court case. Well, interesting. I don't think we put motions and stuff in correctly, but this is in order to have an issue heard by your judge, you must file a motion or petition, right? So the motion is going to go into the court case. The petition is going to go to the judge, explaining the issue and explaining that you want the judge to do. You must also give legally sufficient notice of a motion or petition to the other party or party's attorney if the other party is represented by an attorney. Possibly. Or you can ask for an ex parte hearing and see what he says. All motions, petitions, you got to do it in a certain place. What is a notice of motion? Your motion petition must include a notice of motion, which must be filed with the circuit court or clerk of the court. The notice of motion will state the name of the case number, name of your motion, and date, time, place of hearing, including name of judge, and brief description of your motion or petition. All right, so you got your petition of what you want to do, and you need to write a notice about what you want to do. As a notice, in the notice of motion, you must also verify the other party has been served. Now, see, it says in the notice of motion, but it didn't say in the notice of petition. It's interesting how the other party was served. Yeah, right, so that's your certificate of service. You must attach a copy of your motion or petition to the notice of motion. If your notice of motion is not completed properly, the court may deny your motion petition. You must attach a copy of your motion or petition to the notice of motion or petition. So if somebody sends you a notice of suit pending, the pending suit needs to be attached to it. The lis pendens is a notice of suit, but it doesn't have the suit attached to it. Not only that, they never really send it to you. They put it in the Register of Deeds office because nobody can find you. Can't find the owner. He's unknown. Who do I serve notice to? If the other party is not represented by attorney, you give it to them. Otherwise, you give it to the attorney, right? You don't need to send it to anybody else, but the party is represented by attorney. You must serve the attorney, not the other party. How do I serve notice? Got lots of ways. You can drop it off in their mailbox. Personal delivery, right? You can drop things in a judge's mailbox. So if you wanted to put a motion into a court case for a judge, you could put him on the certificate of mailing that you've sent it to the judge. I think I would. You can do it by fax machine. This pretty much says unless they've rescinded the consent, it's already presumed that you can. You could just fax it to them. They may not take it after that, but, you know, since they didn't say no yet, they have to take the first one. When? Well, at least 2 days before court for personal service, or 5 days before court if you're doing it through the post office. Now, this isn't anything new, right? Just if you don't have your notice of motion together and send them together, you haven't properly noticed the other party. Motions, petitions filed with the court must be signed either by the party who is filing the motion, the party's attorney. If you have properly signed your motion, motions, petitions must have a basis in law and in fact, right? So you need to point out the law that they're violating and show them the facts that substantiate your claim. So for me, what they're violating is a certain set of right, Michigan compiled law, Act 101, 1907. I could put that, or carrying on business under an assumed or fictitious name. So they're violating MCLA 445.1 through 445.5. I don't need to tell him any more about that. I just need to give him some facts. He can go read the law and see if I'm correct. But just tell him what laws it is they're violating. MCLA 445.1 to 445.5 for me. And that's because it's right there at the top of the form. So that's what they're violating. And then what are the facts? Well, you know, the fact that they won't take my $6 and put a file number on it, and then take my $10 and show me that it's been indexed properly. They want to do it by their custom. So, you know, don't be shocked if when you go there they don't just bend over and do this for you. All right, you better be ready. So you have your complaint ready. Well, I'm going to go file this complaint. Or then give me a complaint. I want to file a complaint against your office for judicial review of your decision to not follow the law. That's what it comes down to. Judicial review of their decision not to follow the law. Because you can do a judicial review against the clerk's office. So, it's not the attorney that can tell the clerk that you can't do it. The clerk needs to tell you can't do it. If the clerk won't tell you can't do it, you can do a judicial review against them for not doing it, not following the procedures. And I think that was about it. And I'm about wore out. So let's see what else I got here. Did that one, did that one, did that one. I did this. Okay. Anyways, I think that's it. More later when I get my head cleared of what I just got rid of, and we'll come up with the next